Hi guys. Firstly, my name is Muhammad Hafiz bin Muhammad Aziz. My metric number is DIB 202002. For my group assignment, we decide to choose one topic, which is when a contract considered void. So I already choose my part, which is the introduction part. So now let me explain to you the definition for this topic. First, a void contract is a formal agreement that effectively illegitimate and enforceable from the moment it is created. A void contract differs from voidable contract because while a void contract is one that was legally valid to begin with and will be never enforceable at any future point in time, a voidable contract may be legally enforceable once underlying contractual defects are corrected. At the same time, void contract and voidable contract can be nullified for similar reason. A contract may be deemed void if the agreement is not enforceable as it was originally written. In such instances, void contract also refer to the void agreement, involve agreements that are either illegal in nature or violation of fairness or public policy. A contract may be deemed void if it is not enforceable as it was originally written. Void contract can occur when one of the involved parties is incapable of fully comprehending the implication of the agreement, like when a mentally impaired individual or inebriated person may not be coherent enough to adequately grasp the parameters of the agreement, rendering it void. Agreement entered into by menace for the illegal activities may also be considered void. So I think that's all my explanation for my part, which is introduction part. Thank you guys.
Hi, Assalamualaikum. My name is Anisra Aisyah binti Zulkifli. My metric number is DMS 193022. I will cover part of causes of contract void and examples. Causes of contract void and examples. The contract void can occur due to the following reason. First is incompetence. Incompetence means an agreement made by incompetent parties. If one party is incompetent, they legally become unable to agree to a contract. For the examples of contract void due to incompetence are: first is mentally being incapacitated, second is declared mentally incompetent, and unable to make a proper judgment, and the last one is under the age of consent. I would like to share to you the scenario of this incompetence issue. For instance, the person enters into an agreement with a music label to split royalties from his new album 50/50. However, at the time of this agreement, she or he been drinking at the bar for several hours and is heavily inebriated. Due to the fact she or he was incompetent at the time, it is a void of contract. Second causes of contract void is unlawful object or consideration is involved in the contract. Means the contract can also be considered void when the object of the contract or the consideration is prohibited by law. They become illegal, and so any such contract can no longer be valid. For examples of unlawful object or consideration is: first, object includes acts specifically punishable by law. Second is appropriate authorities prohibit through rules and regulations. Third is the rules made by such officer are not in conformity with the law. And the last one is consideration or object defeats the provision of the law. I would like to share to you the scenario of unlawful object or consideration is involved in the contract. For instance, is A get a license from the forest department to cut grass of a certain area. Department officials told him that he could not pass on such interest to any other person. But there is no such law in the Forest Act, so A sold his interest to B, and the contract was deemed valid. Third causes is consideration is unequal. Consideration is unequal means like consideration is not adequate if it involves as illusory promise an item that is worthless. The examples of contract void due to consideration is unequal are: first is has no legal value, second is no right to refund of deposit, and the last one is fake money. I would like to share to you the scenario of consideration is unequal. For instance, a small business enters into a 2-year contract for internet service. Under a term of the contract, the internet service provider has the right to change its price or service at any time without prior notice to the small business. The small business does not have the right to end the contract even if the internet service provider increase the price significantly. This term is likely to raise concern as it allows the internet provider to unilaterally increase the price, varying one of the most important terms in the contract. For the second scenario is a small business enters into a contract with a supplier to buy car parts. Under the terms of the contract, the parts must be supplied by a date specified in the contract. If the supplier is unable to supply the parts by the deadline, the small business has the power to terminate. This term is likely to raise concern as the term penalizes the small business for terminating the contract in circumstances where the supplier has not met its obligation under the contract.
Assalamualaikum. My name is Rizwan Yusof and my metric number is DIB 202001. I will be continuing causes of void contracts and examples. Number 4, fraud. Wherever a person causes another to act on a false representation which the maker himself does not believe to be true, he is said to have committed fraud. Examples of fraud would be intentional misrepresentation, making a false statement, or a plaintiff relying on fraudulent statements. A common example of fraud would be when the plaintiff believes that what they are agreeing to is not legally binding, when it actually is. In layman terms, they were tricked into signing a document. Moving on to number 5, common mistake. In cases when there is a mistake of fact, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as a matter of fact. Examples of common mistake would be existence of goods under a sale of contract, quality of the subject matter is essentially different than what was contracted for, and the intention of one party is different than what it is on the written document. A good scenario that illustrates what is a mistake in contract law is the case of Ruffles versus Witchell House. There was a contract to ship merchandise on a vessel named Peerless. However, the parties involved had a different understanding of each other. Each party was referring to a different vessel, and therefore they did not agree when to ship the merchandise. In this case, both parties thought they were in consent until they realized they were both misguided about each other's different meaning. As such, an agreement was not formed since there was no mutual assent between the parties involved in the formation stage of the agreement. Moving on to the final cause of void contracts and examples is invasion of public policy. Public policy refers to society's social and legal guidelines. Contracts that violate this cannot be legally enforced, even if it is agreed by both parties. Examples of invasion of public policy is contracts that would cause injury to public servants. For example, a Supreme Court has ordered a contract which involves banning the usage of firearms for police officers. This would inflict major injury and even death for public servants such as police officers, especially when facing major threats such as criminals or wild animals. The next example, agreements that would promote slavery. In 2015 and 2016, across two separate criminal trials, 3 men were convicted of modern slavery offences for their role in trafficking workers and forcing them to work in a mattress factory in Dewsbury, West Yorkshire. The mattress factory manager was convicted, as well as 2 Hungarian nationals who had recruited victims in Hungary on the promise of good work in the factory, food and accommodation in the UK. They had trafficked up to 50 men from Hungary to West Yorkshire. On arrival, the victims were forced to work in the mattress factory for as little as £10 per day, for 10 to 16 hours a day for up to 7 days per week. Some of the victims had their passports confiscated and survived on scraps of food, with up to 42 men forced to live in squalid, cramped conditions in a 2-bedroom house. The exploitation was uncovered when one of the victims reported to an NGO, and subsequently there was a large and complex police investigation. The mattress factory that supplied beds to major UK high street retailers who were reported to have previously audited the factory but not uncovered the slavery happening there. And finally, contracts involving trading with the enemies of the state. A common scenario which is happening behind the scenes is sellers supplying illegal weapons and drugs to enemies of the state such as Israel and North Korea through the black market. Contracts that involve trading with the enemy, especially at times of war, will result in penalties such as life sentences, in prison or even death sentences. Thank you.
My name is Nurika Isabdi Shamsul. My metric number is DMS 13011. Today I will continue from my part, which is about key elements to a contract and factors that make a contract void. What are the key elements to a contract? For the first key, offer and acceptance. Firstly, one of the parties must offer goods and services to the other. This offer must have the details set out so that both parties are fully aware of the content of the contract. The other party then accept that offer. The second key, consideration. There must be a valid reason for the two parties to enter into the contract, and there must be an exchange of value between the parties. The third key could be intention to create legal relations. The two parties must also clearly intend to create legal relations and are willing to bind themselves to those obligations. And the last key is certainty and competence. The parties must also be competent to enter into a binding contract. In addition, the terms of the contract must not to be vague or uncertain, as this will make the contract unenforceable. We move to another content is factors that make a contract void. Once you sign a contract, you and the other party are legally bound to perform your obligations under it. However, some factors make a contract void even after it comes into effect. A void contract means the contract is not enforceable, so neither party can exercise their right or performs the obligations under the contract. This article will set out 6 key factors that lead to a void contract. These factors usually reflect that there has been miscommunication around the agreement by either party or the contract is against public policy. These factors could be uncertainty. If the contract uses language that creates uncertainty around contractual obligations, the contract will be void. For example, an agreement to agree within a contract can create uncertainty as there is no clear indication of what will be agreed to in contract. Second factors are incomplete contract. The contract is incomplete if it is missing an essential term. And essential terms means that the contract cannot be performed without the term included. Examples of essential terms include an agreed price for a starting date for a lease. Third factors are common mistake. A common mistake is when both parties are mistaken about the subject matter of the contract. For example, if one party agrees to buy a painting from the other party, but the painting was already destroyed by fire, that would be a common mistake that will void the contract. Four factors are lack of capacity. All parties are presumed to have the mental capacity to understand the nature and effect of the contract. If they demonstrate a lack of capacity, such as stroke a mental disorder or being under the age of 18 in Victoria, the contract could be made void. Fifth factors are illegality. A contract may be void because it deals with illegal activity. This could be contracts that are directly prohibited by law, such as cartel contracts. On the other hand, there can also be particular elements of contracts that are not allowed under the law, such as unfair contract, terms in contracts covered by the Australian Consumer Law. The last factors could be a public policy. Finally, a contract could be void if subject matter or performance is against public policy. For example, you cannot create a contract that involves slavery.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aina Nur Iman binti Aziz. My matric number is DMS 201011. My part is about conclusion. In conclusion, the contract will be void when it does meet the main elements such as no offer, acceptance, return, and intention. This is an illegal contract. A void contract is defined as a contract that is not legal valid. This contract cannot be continued and must be cancelled. An agreement that cannot be enforced by law is known as void. An agreement cannot be enforced and cannot be restored when it is found to be void. This means that the contract is considered void and invalid from the moment it is first created. But a voidable contract can still be continued at the will of a concerned influencer or deceived party. This means that if it chooses to continue the contract, then the contract will remain in force. If the party wishes to terminate the contract, then he is also entitled to do so on. An avoidable contract is a valid contract, but one of the party has the choice to cancel it. It is considered valid until revoked by the party. This is a right to cancel. When a contract is cancelled, all the promises contained within are not again enforced, and all benefit derived from the contract should be retained as required. That's all for me, and thank you.